However, when selecting the classification of services, it will be more complicated. As far as the designated services are concerned, all services items actually have a basic principle. That is, all services must be providing services for others. That's because a trademark is to protect the commercial interest of the trademark owner, and the so-called services should have a commercial consideration relationship. Trademark owners must provide services for others, and these others, before or after receiving the service, must pay the corresponding service fee. Such commercial activities with a consideration relationship are the services to be protected by the Trademark Act. The concept as opposed to provide services for others is the applicant's internal affairs. Those acts that take place in order to manufacture or provide goods, or acts necessary for the applicant's internal operations, are in this scope. Since these internal affairs are not services provided to others in commerce, they should not be classified to the scope of trademark designated services. For example, if a company which sells computer software, after designate computer software in Class 9 while filing a trademark application, this company is also considering whether to designate computer software design in Class 42 at the same time. The following guidelines should be accorded when making judgments. If computer software design is only the internal affairs of company, that is to say, computer software design is their daily work and is the process of the design and the manufacturing of the computer software that the company sells externally. Under this circumstance, since the said company does not provide services of designing computer software for others, we do not recommend the company to designate the computer software design services in Class 42 in their trademark application. However, if the company designs its own software goods and also provides customized computer software design services, then we can be sure that the services provided by the company conform to the definition of computer software design services in Class 42. Certainly, the computer software design in Class 42 can be designated. Some people may ask, why shall we distinguish carefully between serving others and the applicant's internal affairs? Basically, in the Trademark Acts all over the world, the trademark owners are required to actually use their trademarks on each designated goods and services. Generally, all countries will stipulate that if a trademark is not used on all or partial of the designated goods or services continuously for a long period of time, normally 3 years or 5 years, then the country's trademark office can cancel the non-used part of the trademark ex officio or by a third party's application. According to Taiwan's Trademark Act, if the company mentioned above has designated computer software design services in Class 42 when filing the trademark application, but after registration, it is proved that the company has not provided computer software design services externally for 3 consecutive years, then their trademark and the Class 42 for computer software design will be revoked. That is, its protection will be withdrawn.